You may have a will to declare how you want your assets distributed at your death. Well, a revocable living trust can accomplish the same objectives with more individualized control while saving your loved ones the time and money that probate requires. It is also a great tool to plan for potential incapacity. A revocable living trust is a written agreement that is created while you are alive and can be modified as long as you are competent. In most cases, you will be the trustee and beneficiary while you are alive. If you are married, your spouse can also be a co-trustee and beneficiary until one of you passes away, at which point the surviving spouse then becomes sole trustee. To finalize the creation of your trust, you must transfer property you own into the trust. Even though you're transferring your assets, you remain in total control, and you can withdraw or add property during your life. Transferring these assets will save your beneficiaries time and money by avoiding probate. With only a will, your beneficiaries have to go through probate to retitle the assets that were in your name at death into their name. This court-supervised process could take months or even a year or more to transfer assets. By contrast, your successor trustee can quickly transfer trust property to your beneficiaries according to the terms of your agreement. Another benefit of a revocable living trust is the control over how your assets are distributed. If you don't want a beneficiary to receive his or her inheritance outright, you can set up restrictions on how and when it will be distributed. Another common reason to set up a trust is for the benefit of a minor or special needs individual. Having provisions in your trust for a minor avoids the court appointment of a guardian of the property, someone you may not even know. It can also prevent the release of funds in one lump sum when the minor reaches the age of majority. For special needs individuals, having funds in a trust can allow access to the money to increase their quality of life while protecting their public benefits. In addition to giving you greater control and flexibility, a trust also helps protect you in the event of incapacity. And with longer life expectancy, the risk of incapacity is increasing. It is not a pleasant thought, but who would manage your financial affairs if you are unable to? Without proper planning, a court-appointed guardianship may be required. With a revocable living trust, you can avoid this court intervention by naming a successor trustee to manage your financial affairs should you become incapacitated. If a revocable living trust is right for you, an important decision is who should be your successor. You can name a family member, a friend, or a corporate trustee like Members Trust Company. You should carefully consider the risk of a family conflict if you named a family member, and also the ability of that loved one to assume financial management of assets held in the trust. There are many benefits to having a corporate trustee, including administrative expertise, investment management expertise, and impartiality. For over 30 years, Members Trust Company has assisted families like yours by serving as successor trustee of revocable living trusts. And we can even provide you with a list of local attorneys who specialize in estate and trust law to get you started. Give your Members Trust Company representatives a call to evaluate the benefits and costs to determine if a revocable living trust is the right fit for you and your family.